Thank you so much. I appreciate the time. I'm Sandra Michaels with the Georgia Association of Criminal Defense Lawyers. Thank you, Chairman Willard. We were one of the original stakeholders that worked very hard through Laura Hogue and Don Samuel were members of the original group. We were not a part of the group this summer that worked on this bill. Therefore, we are in support of HB 1. We always have been. Civil forfeiture reform is a very important thing in Georgia. As Mr. McGrath noted, we do have some of the worst forfeiture statutes. However, we are concerned that a lot of what we believed were coming together and cooperating with Chairman Willard on certain give and take on the bill lost its way through the most recent bill. And particularly, we agree with folks that said, and specifically on page 9, line 276, the compromise was down to a $5,000 threshold. What this means in practical terms is any amount can be seized under $25,000 without the state having to file any reason for doing it. They can take any property under this amount without having to show why they took it. That's a problem. We conceded, maybe with Chairman Willard, that perhaps $5,000. That was the agreement that folks agreed on, $5,000. I know the prosecutors objected, saying that was too low. In the spirit of compromise, we offered maybe $10,000. But $25,000 is a very high threshold where you can lose your property. There's cars worth under $25,000, jewelry, money, items taken. The state should have to file something under oath for a certain amount of money before they take your property. It's just fundamental fairness. I understand there was objections to the $5,000, but $25,000 is really, really too high, to be fair. The second issue we have is, and I think it's been addressed, but it bears repeating because I want you to know that as original stakeholders, this was something very important. On page 16, line 551, preponderance of the evidence is a standard that most of the other states do not use. It should be clear and convincing. That is what the original group agreed upon. There's states that even have higher standards. I understand the prosecutors and the sheriffs were not happy with that, but we would recommend the committee look at changing that. We very strongly believe on page 17, line 558, 559, 560 should be deleted, along with section G. The innocent owner, the way this is written, did not know the conduct giving rise to the forfeiture was likely to occur. All of us can sit here and think of circumstances where family members or something have some kind of issue. Maybe they've had some kind of drug problem in the past, but does that mean you as the parent should lose your car because your child used the car and did something illegal? The defensive should have known is just really loose, a very loose one, and it's not in a protection of the innocent owner. This legislation started out, I want to say it might have been 2 years ago, I might be wrong, Chairman Willard, and one of the main things above and beyond the reporting, which we totally support HB 1's reporting changes, that's wonderful. The component along with the reporting was the innocent owner protections. There's no protection for the innocent owner in this legislation. And to do that, D and E should be removed. Should not have reasonably known, which is line 559, should not have reasonably known the conduct giving rise to the forfeiture. What does that mean? Should not have reasonably known? That is an extremely high burden to meet. And finally, 9/16/17, which is line 583 for those trial lawyers here, there shall be a rebuttable presumption that any property of a person is subject to forfeiture under this chapter if the state attorney establishes by a preponderance of the evidence. Meaning, think about that, for those of us who have to do this in federal court, that means that the owner, the property owner, has the burden of proof to show that there's any of this. All the state has to do is show, well, they could have been involved in some giving rise to forfeiture, they engaged in conduct, was acquired during the period of the conduct giving rise to the forfeiture with a reasonable time, or there's no likely source. basically the state would just have to say that, and it would be the burden upon the property owner to show that wasn't true. And we would object to the rebuttable presumption part. That's just not, it's not like not a fair way to do the forfeiture. Again, we appreciate being involved in the original group. We would like to meet with any of the committee members. I know that it's not just the criminal defense bar. There's a lot of people that are concerned with this. Although we do very much appreciate most of the House Bill 1, we would like to see the burden of proof change and the provisions to help innocent owners be strengthened. And again, the part about the spouse or the dual owners is a very serious consideration this committee should look at. Thank you.
Questions for Ms. Michaels? Seeing none, thank you for your
Thank you.
testimony today.
Appreciate your time.
Mr. Foster.
Okay. Thank you, Chairman Jacobs, members of the committee, Representative Willard, for the work that all of you have done on this legislation. My name is Joel Foster. I'm the State Communications Director of Americans for Prosperity, Georgia. We are the state's largest grassroots organization for promoting economic freedom. About 60,000 members spread out around the state, and so we appreciate the opportunity to speak to the legislation today. And I won't take very long. My comments will be very brief because we have worked, and it's been our pleasure to work with both the Institute for Justice and the ACLU of Georgia on kind of reviewing the legislation itself. So many of the comments that I would make were articulated by the guys that came before me. But I just would point out that we are very appreciative of the process that has gone into this and the months-long process that has gone into it. We believe that this is a good piece of legislation in several areas. We do appreciate the transparency requirements that have been placed in the legislation that place additional safeguards and additional accountability on the government agencies that serve us, law enforcement that serve us. We also, it kind of reduces the concern that some of us have at the grassroots level and citizens in the state that forfeiture proceeds are misappropriated at times, and some of the stuff that we've read about in the news here in the last year, and provides a layer of government accountability. I would point out that as a grassroots group that promotes economic freedom, the free market system that we talk so much about at AFP is truly underpinned or undermined based on the security of an individual's property and the feeling that they have that their property is secure. The law has an inextricable impact on the perception of a citizen's rights of ownership over their own property and the course of representation that they get in ensuring that that property is theirs and theirs to keep. The ultimate point is that a citizen needs to feel like the law is serving them, not that they are being, not that it's working against them. So I say all that to say that suspects, I think, in civil forfeiture proceedings often have difficulty with some of the paperwork, without the legal counsel that they often cannot afford, because some of these cases are pretty low dollar amounts. So it takes legal counsel, legal representation on the table for many of them. And there are some procedures. We've talked about the paperwork today. We've talked about some of the filing procedures involved in appealing an asset that is under question, that's under seizure. We do not feel that they should be penalized without the opportunity to have the property at question determined on the merits rather than just on their technical ability to fill out paperwork or whatnot. And that's certainly something of concern to us. We also have the concern, as was stated a little bit earlier, that the innocent owner who is associated through shared ownership of the property with perhaps a spouse or whatnot, the property in question with the suspect, they should not be placed in a position where they lose the property without the ability to question the determination, simply because it's a guilt by association type of arrangement, which is the fear that we have there. Outside of that, I just underpin that we are in support of the legislation based on what it does currently. We stand beside our friends from IJ and the ACLU, Common Cause, the Tea Party groups that were mentioned. And in saying that it's a start, that we do ultimately at AFP, we would love to see a criminal process rather than the civil process that we currently have in place. So we look forward to continuing to work well beyond the session, I'm sure, on the issue at hand. So I thank you all for your time, and any questions or comments, feel free to answer.
Questions for Mr. Foster? Seeing none, thank you for joining us today.
Thank you all.
My name is Frank Rotondo. I'm the Executive Director of the Police Chiefs Association. We received a copy of the substitute via email 2 days ago, so my full board hasn't had time to vet this. But I did, as well as our attorney and several other people on my board, and we find this a very acceptable bill. And I thank everybody on the committee for the cooperation in going forward with the bill and working with Representative Willard, or Chairman Willard.
Right.
And thank you.
Mr. Chairman, Frank Rotondo and his organization have all been very open with their comments and issues, and very appreciate your involvement.
Thank you, sir.
I very much appreciate that, Mr. Rotondo, and I'll just say, I mean, from my standpoint, I appreciate your willingness to work with us. I appreciate the DA's willingness to work with us. I view stuff like this as just playing games, and that's just the bottom line. So
Thank you, sir.
thank you. All right, so that being said, we're going to go ahead and suspend on House Bill 1. I do expect that the next time this bill comes up, we will have a subcommittee vote on it. I encourage members of the subcommittee to read the bill. Also go through the comparison document that you have been emailed, which is a good way to compare the last version of the bill that we had last year with the version we now have.